With your indulgence, I would like to say a few words of welcome before handing over to the Lady Chief Justice to introduce our esteemed speaker today. For those of you who don't know me, I'm Paddy Kelly. I'm the Director of the Children's Law Centre, which is a registered charity and the jurisdiction's leading children's rights NGO. The Centre engages the law to systemically vindicate the rights of all children, but especially the most vulnerable. Lady Chief Justice, Lord Justices, members of the Judiciary, colleagues and friends, on behalf of the Children's Law Centre, I would like to extend a very warm welcome to you to our 2025 annual lecture. I'd also like to extend a warm welcome to those joining us via live stream, colleagues from academia, the legal profession, sister NGOs, statutory partners, and those joining us from other jurisdictions. You're all very welcome. I would like to extend a particularly warm welcome to Judge Síofra O'Leary, who, despite being on a sabbatical, very generously agreed to deliver this year's lecture. And despite what other people are claiming, she very kindly brought the weather with her. As you will know, Judge O'Leary is the immediate past president of the European Court of Human Rights, having been appointed to the court in 2015. Having read her very extensive and highly impressive CV, a copy of which you'll find in your packs, we are extremely honoured, and I can think of no one more appropriate to deliver the Children's Law Centre's 2025 annual lecture. I am particularly delighted that Judge O'Leary has agreed to deliver what will be the last annual lecture of my time as Director of the Children's Law Centre, and that the title of her lecture is Children's Voices and the Law, Reflections on the Role and the Contribution of the ECHR. The very first public event I organised after establishing the centre was in December 1997. It was organised in partnership with Professor Christine Bell from the then Centre for International and Comparative Human Rights Law at QUB, and was entitled Children's Rights and the Incorporation of the European Convention. It was organised in anticipation of the incorporation of the ECHR into domestic law through the Human Rights Act 1998, with Professor Ursula Kilkelly delivering a paper entitled Children and the European Convention on Human Rights, Implications of Incorporation. Our hope at that time was that post-incorporation, the potential of the Convention to deliver domestically in respect of children's rights might be more fully realised. Thanks to the work of many in this room and online, a lot has changed in the realising of children's rights since 1997, as we'll hear shortly from Judge O'Leary. However, much remains to be done. As is evidenced from CLC's work and from what young people tell us, it is not a given across all duty bearers that children are viewed as autonomous rights holders. Regrettably, as evidenced by the denial of the rights of, for example, disabled children and refugee and asylum-seeking children to access education, health, housing and safeguarding, the enjoyment of rights is not experienced equally by all children in this jurisdiction. The voice of the child is all too often not heard by duty bearers when decisions are being made about their lives. In breach of the UNCRC, at 10, we still have one of the lowest ages of criminal responsibility in the world, and children in Northern Ireland do not enjoy the same protections from assault as adults enjoy. It is to be hoped that the Justice Bill currently making its way through the Northern Ireland Assembly will address the latter two children's rights deficits. 25 years on from the Human Rights Act coming into force, it is therefore important to not only reflect on how much has changed and how children's rights are better protected in law, policy and practice, and the important role the European Court of Human Rights has played in securing those rights, but also to reflect on what remains outstanding and how, in challenging times, we can best secure what has been achieved and ensure the onward progression of protection the rights of our most vulnerable citizens. Today's lecture will undoubtedly provide us with significant insight, wisdom and inspiration to inform that reflection. And finally, Lady Chief Justice, May I thank you on behalf of the Children's Law Centre for kindly and so readily agreeing to chair today's lecture. We are very appreciative of you giving so generously of your time, especially given your considerable commitments.
Distinguished guests, colleagues and friends, it is my privilege to provide some opening remarks at this, the Children's Law Centre Annual Lecture 2025. I think it's fair to say that this event has been a highlight in our collective calendar, bringing together those committed to upholding the rights of children and young people. This evening we gather once again not only to reflect on the remarkable work of the Children's Law Centre, but also to, I think, reaffirm our dedication to the principles of justice and fairness for children in Northern Ireland. I recall chairing this event in 2019 when Baroness Hale delivered a thought-provoking lecture on the issue of children's rights. That event reinforced my belief that the law must remain an unwavering guardian for our children, ensuring that they are seen, heard and protected. Now, 6 years later, I return with that same sense of duty and commitment. For me, this is not just a formal occasion. My career at the bar, as some of you will know, was deeply rooted in family law. And during those years, I saw firsthand the transformative impact of the Children's Law Centre. I witnessed the power of its advocacy, the depth of its expertise, and most importantly, the real change it brought to the lives of vulnerable children and their families. Whether securing essential educational support, fighting against unlawful exclusions, or ensuring that children in care had their voices heard, the Centre's work was and remains critical in this jurisdiction. I'm particularly pleased to welcome this afternoon's keynote speaker, Judge Síofra O'Leary. Her distinguished career, most recently as President of the European Court of Human Rights, has been marked by an unwavering dedication to human rights, including the rights of children. And I'm particularly pleased that she is giving this lecture on that specific topic. She has, of course, had direct experience of cases before the European Court of Human Rights, and I can't help but mention her decision and the case that she presided over in the Grand Chamber in Duarte, Agostinho and others versus Portugal. The reason I mention this is that some of the litigants in that case, which was about climate change, as some of you will know, were children, 6 young Portuguese applicants. They did starkly present the impacts as they saw it of climate change on children's fundamental rights under the European Convention. While ultimately that case was found to be inadmissible due to a failure to exhaust domestic remedies and a lack of extraterritorial jurisdiction for most respondent states, it signifies, I think, the increasing urgency and legal relevance of environmental threats to the youngest generations. And it also signifies that children can be effective litigants. I noticed in the press just this week that a group of young girls are trying to take a case in relation to educational provision, possibly inspired by other litigants across the world. It's not surprising. Children occupy a unique place in society. They are our future, yet among the most vulnerable. They rely on adults and the systems that we create, including the system within law, which is provided to safeguard their rights and well-being. The United Nations Committee on the Rights of the Child echoes the urgency with which children are engaged in relation to climate in the General Comment 26, stating the triple planetary crisis is an urgent and systemic threat to children's rights globally. That's only one element of the issue of children coming before the court. But the centrality of children in our legal system is also well represented in other ways. The paramountcy principle, or the best interests of the child, finds expression in many instruments. We are all familiar with the United Nations Convention on the Rights of the Child, which serves as a cornerstone of children's rights worldwide. It enshrines the fundamental principle that every child has the right to education, to healthcare, to protection from harm, and most importantly, to have their voices heard in decisions that affect them. Article 12 articulates the right to be heard. This right is, it seems to me, well embedded in our domestic law, and this reflects the emphasis in the UN Convention on the Rights of the Child. Pausing for a moment, this convention, while ratified by almost every country in the world, including the United Kingdom in 1991, has of course often remained separate from domestic law, limiting to some extent direct enforceability in national courts. I noticed with interest that Scotland has incorporated the United Nations Convention on the Rights of the Child recently. But it seems to me within our domestic jurisprudence in relation to children's rights, certainly in my experience in family law, we are well aware of the need to consider the voice of the child within proceedings. As an aside, I was recently speaking at a Commonwealth Lawyers Conference in Malta last month, and I spoke about Northern Ireland to the audience, and I happened to mention the United Nations Convention on the Rights of the Child and family law, and I'm glad I did. It was the one area that attracted debate among the attendees, and in particular, a judge from Trinidad and Tobago asked me a question, firstly about incorporation, and I tried to explain the position on that, but the fact that we, in our jurisdiction, respected the right of the child to be heard. And then she said, but do you not realise what's happening across the world where we don't have the rights of the child heard, and the issues that we have with children being imprisoned, children in poverty, children lacking education? And it brought home to me how important a debate about this is. In this jurisdiction, which is away from Trinidad and Tobago and other jurisdictions, it seems to me that whilst we have made progress, whilst we are cognizant of children's rights, challenges also do persist. Child poverty remains a pressing issue, disproportionately affecting certain communities and limiting access to education, healthcare, and social support. The mental health crisis among young people has reached alarming levels, with services struggling to meet demand. In our youth justice system, we still grapple with the tension between rehabilitation and accountability, and too many children find themselves navigating a system ill-equipped to support their development. As members of the judiciary, we bear a solemn duty to ensure that the law works for all children, not just those with the means of access to justice. And this, to my mind, requires ongoing evolution, specialised training in children's law, and a judicial approach which prioritises fairness, protection, and accessibility. On this note, the Children's Law Centre stands as a beacon of advocacy, legal expertise, and unwavering commitment to the rights of children. if I may say something about Paddy Kelly at this stage. Since its founding in 1997 by Paddy Kelly, the Centre has transformed the landscape of children's rights advocacy in this jurisdiction. Its work is vast, encompassing legal advice, representation, policy development, and strategic litigation. I can't fail to be impressed by the achievements that the Children's Law Centre has attained, driven, I have to say, by Paddy. The Centre, as many of you will know, provides a free legal advice service, ensuring that children, young people, parents, and carers can access expert advice. It also offers a multidisciplinary team of lawyers, trainers, and policy advisors dedicated to upholding children's rights. And this team ensures representation in complex legal cases, including education law, mental health appeals, and youth homelessness advocacy, as well as acting as third-party interveners in key legal battles. These are not merely hypothetical scenarios. They are real cases, real lives changed, and systemic processes challenged by the vital work of the Children's Law Centre. And I think today we should pause to recognise Paddy Kelly's commitment and leadership of the organisation. So very finally, may I say, as the Children's Law Centre enters this new chapter, I'm not sure what we're going to do without you, Paddy.
I'm sure you do very well.
But as we enter this new chapter, the question before all of us is, how do we build on the foundations that I've spoken about? How do we continue to strengthen legal protections for children and ensure that access to justice is not a privilege but a right? I think that the Children's Law Centre is in safe hands in relation to that, and I'm sure that Paddy's successor will take up the mantle. But furthermore, as we look to the future, we must acknowledge, it seems to me, the changing fabric of our society. Northern Ireland is becoming increasingly diverse, welcoming families from numerous ethnic and cultural backgrounds. Many arrive from countries where the landscape of children's rights, state support, and legal protections differs significantly from our own, or where the expectation of such robust, independent advocacy for children may not exist. Many are vulnerable. It is imperative that the Centre's vital work proactively expands to reach all children within this jurisdiction. It seems to me that we are well mapped on the need to ensure that language barriers, cultural misunderstandings, or lack of awareness do not prevent any child, regardless of their origin, from accessing the protections and support that organisations such as the Children's Law Centre offers. So let me leave you this evening on that note. I hope not just informed by the work of the Children's Law Centre, but inspired to listen, to act, and to ensure that we keep in mind children's rights. I'll finish now because you are going to be treated to a lecture from someone who is well placed to speak on this topic and who has prepared a lecture which is expansive, informative, and thought-provoking on the issue of children's rights. So I pass to Judge O'Leary.
Lady Chief Justice, distinguished guests, it's a real pleasure to be back in Belfast. It's not a city I had previously associated with the word balmy, but I'm glad if you attribute it to me. My warm thanks to the Children's Law Centre for organising this event. And I'd like to echo in my opening remarks the statement of the Lady Chief Justice. I know how much Paddy has done for the Centre. I only met her today, but I knew before I met her that she's a force of nature. I know how well respected she is in this community and beyond, and how much she will be missed when she steps back in June. I'd also like to thank the Lady Chief Justice for chairing this session. I know just what your job involves. I'm extremely grateful that you gave of your time to be here with us. Our paths crossed several times during my time in Strasbourg, and particularly when I was President. And on each occasion, I thought how fortunate this jurisdiction is to have someone like you at its helm. In 2017, in a case called Unison, which some of you will know, explaining why courts provide a public service like no other, Lord Reid stated, and I quote, "Every day in the courts and tribunals of this country, the names of people who brought cases in the past live on as shorthand for the legal rules and principles which their cases established. This is equally true of convention cases. Strasbourg litigants have had to exhaust domestic remedies on their long road to individual justice or the vindication, creation or clarification of convention legal rules and principles. When successful, their cases have the capacity to alter the minimum standards applicable throughout the vast convention legal space. One of the earliest landmark judgments of the Strasbourg Court, which recognised the Convention's character as a living instrument, was a case called Tyrer against the United Kingdom. Some of you here present probably know the case. It involved a 15-year-old Manx resident who in 1972 was sentenced to 3 strokes of the birch on his bare posterior for an assault on a fellow classmate who had snitched about beer being taken into the school. At a time when most of us have seen the Netflix series Adolescence, one might feel a certain nostalgia nowadays for the days when beer, snitching and a schoolyard brawl were the order of the day. But I mentioned Tyrer because the differences between the majority of the court in that case and the national dissenting judge, I think, are very instructive for our reflections today. According to the majority, and I quote, "The very nature of judicial corporal punishment is that it involves one human being inflicting physical violence on another human being. Furthermore, it is institutionalised violence." The heart of the dissent by Sir Gerald Fitzmaurice, who may be known to many of you here in the room, can be found in footnote 7 of his separate opinion, in which he stated, "Throughout the ages and under all skies, corporal methods have been seen as the obvious and natural way of dealing with juvenile misbehaviour." But he also set out very clearly the origins of his views. He wrote, "I have to admit that my own view may be coloured by the fact that I was brought up and educated under a system according to which the corporal punishment of schoolboys was regarded as the normal sanction for serious misbehaviour, and even sometimes for behaviour which was much less serious. Yet I cannot remember that any boy felt degraded or debased. Such an idea would have been thought at the time as rather ridiculous. Indeed, such is the natural perversity of the young, of the human species, that these occasions were often seen as matters of pride and congratulations." I think it's fair to say that the spirit of the dissent hasn't stood well the test of time. Reports north and south of the border, and indeed to the east and west, speak of institutionalised violence and abuse of children and the vulnerable in educational and reform establishments at the hands of the state, or with the state and its citizens turning a blind eye or a deaf ear. Some of you will have no doubt read about or read the recent Farrelly report in the South. Strasbourg judges are charged with the interpretation and application of a 75-year-old convention, whose 14 principal articles and additional protocols touch on almost every aspect of human life and a person's interaction with the state. But this was not an instrument established with the rights of children in mind. And in the time available to me this afternoon, what I'd like to do is to illustrate, or try to illustrate, how over time the Strasbourg Court has sought to hear better and protect more effectively the voices and rights of children in legal proceedings. And look at how children's voices have been, I would call it, lost and found in convention case law, touching on cases of surrogacy, child placement and adoption, and domestic violence. In these areas, we see the depth and potential destructiveness of the human desire to procreate and parent. We see how the state can fail the very children in their supposed attempts to protect them. And we see the targeting of children in our society as a means to inflict harm on others. Turning thereafter to more positive themes, I'll try to illustrate how, over time, the Strasbourg Court has become more sensitive to the voice of children in its approach to child-friendly justice, and how it has sought, more recently, to get around the experience of children and their future prospects being ignored in and by an adult world. I don't suggest that the Strasbourg Court was or always is a pioneer. It has usually been national children's advocates, like this centre, national judges and national courts, which have led the way in this field, and in the course of my speech I'll refer to one stellar example from Northern Ireland. The value of the Strasbourg system, however, and an enduring value to which I will return in my conclusion, is the determination in the general interest of issues of public policy, thereby raising the standards of protection of human rights and extending human rights jurisprudence throughout the community of the 46 Convention states. This may mean that where a judge in Belfast has led the way, a judge in Chisinau or Madrid may in time follow suit on foot of a Strasbourg judgment which has a declaratory nature, but one which also has a res interpretative effect. Turning first to the question of surrogacy, whether working as a single judge on a committee of 3 judges, in a chamber of 7 or the Grand Chamber of 17 judges, I always felt during my 9 years that one of the bigger challenges facing convention judges is to ensure that over time and across all the different facets of law and life with which they're dealing, they remain fairly consistent and coherent in their approach to convention questions. And it was in surrogacy cases that I must admit to finding this obligation particularly challenging. In these cases, there are 2 basic underlying principles which recur in the case law. Firstly, where ethically sensitive issues are at stake, member states are afforded a wide margin of appreciation. The Strasbourg Court's task is not to substitute itself for competent national authorities in determining the most appropriate policy for regulating the complex and sensitive matters involved in children born of surrogacy arrangements with the help of medically assisted reproduction techniques. Secondly, in these cases, all decision makers, national and European, administrative and judicial, must be guided by the best interest of the children involved, as the Lady Chief Justice has emphasised. So far, so good. These are 2 general and eminently sensible propositions. However, the challenge comes in applying these principles to a myriad of different regimes across 46 different member states, some of which prohibit surrogacy and others of which tolerate it but don't regulate it, to a range of different personal relationships amongst intended parents, which relationships are governed by a host of different national laws and policy, and to which one must also add the possibilities now afforded by science, which for many years has put pressure on the established dictum of mater certa semper est. In a case called Paradiso in Campanelli, it was one of the first Grand Chamber cases I sat in as a baby judge, and I would rank it still as one of the hardest cases in which I sat. A majority of the Grand Chamber found no violation of the private life limb of Article 8 of the Convention. The case concerned the removal of a child born abroad as a result of surrogacy arrangements entered into in Russia by an Italian couple, the applicants. The courts considered that the conditions for the existence of de facto family life within the meaning of Article 8 of the Convention hadn't been met, because for the court the case concerned applicants who, acting outside any standard adoption procedure, brought to Italy from abroad a child who had no biological tie with either parent and who had been conceived through assisted reproduction techniques that were unlawful under Italian law. According to the intended parents, the commercial surrogacy arrangement had involved the provision of sperm by the intended father. In other words, a biological link had been intended, but it wasn't clear from the facts of the case why this hadn't been followed through in Russia. One of the undoubted consequences of the court's characterization of the case in the manner which I've just described, and in particular the absence of a biological link, was that the Grand Chamber validated the decision of the Chamber, which had already looked at the case, to refuse the parent applicant's standing to act before the court in Strasbourg on behalf of the child. There are different ways of looking at the Paradiso judgment. On the one hand, given the ruling about standing, the voice of the infant child was nowhere to be heard. He had been born into this world via a legally very precarious route, but it wasn't a route of his own choosing. He was removed from his only known environment, aged 8 months, and continued to be the subject of legal proceedings for 6 long years thereafter without anyone being accorded rights to participate on his behalf in the Strasbourg proceedings. On the other hand, the majority judgment, by approving the Italian authorities' decision to remove the child from the intended parents, was seeking to protect the best interests of children generally, in light of the commercial nature of the surrogacy arrangement and the indices of fraud which had emerged in this particular case. But the fate of a child born of a long-standing desire to parent, but dogged by the legal precarity again of the route that was chosen, is also on display in a Norwegian case, a case called AM against Norway. The applicant's complaint related to the refusal of Norway to recognise her as the mother of X. The applicant and her former partner, EB, had tried unsuccessfully to have a child during their 10-year relationship. Their first attempt, when still a couple, to have a child via surrogacy had failed, but they continued their efforts even after the relationship had ended and EB had embarked on a new relationship with another woman. X was born in the US in March 2014 and spent the first months of his life in the care of the applicant and EB. They then agreed to share responsibility for him, albeit in their separate homes, and the child was shuttled between the two homes until child welfare services became involved at the request of the paternal grandmother because of levels of conflict which were emerging. In August 2015, EB, who is now the father of a second child in his new relationship, unilaterally cut off contact between X and the applicant. Now, by that time, the child was aged 17 months. And if you think of the facts that I've just described, X had at 17 months, one biological father, EB, one genetic mother, the anonymous donor of the egg, one gestational surrogate mother, KJ, a first social mother, the applicant, based on the fact that she had cared for the child since birth until contact was unilaterally cut off, one legal father, JJ, the husband of the surrogate mother, KJ, and a second social mother, who was EB's new partner and the biological mother of his second child. I've listed all of those parents for a reason. I'm sure it's made your head spin, and it makes courts' heads spin, whether at national level or in Strasbourg. In this case, as in Paradiso, the child's right to formal recognition of his family ties within the meaning of Article 8 wasn't before the court in Strasbourg. As his biological father had sole responsibility for the child under Norwegian law, the applicant had no legal basis to represent the child's interest. So the biological father, in every sense, called the shots. It's difficult, in my view, to find any winners in what are almost always tragic cases of this nature. It's also, and I'm being very open here, I found increasingly difficult to find a coherent line in the court's case law beyond the two general principles I outlined at the beginning. The nature of the couples who have sought to rely on Article 8 has varied considerably. Married, unmarried, same-sex, heterosexual, together, no longer together. In some recent cases, the alleged violations of Article 8 have seemed to reflect the quest of parents, and I underline that this is no doubt legitimate, but it is perhaps misplaced, given the court's focus in all of these cases on the primary interests or welfare of the children. The quest of the parents has been to use the Strasbourg case as a means to further legal battles in relation to their own social and legal rights as same-sex couples. As I indicated in the Norwegian case, by entering a surrogacy arrangement abroad, which practice is not lawful in their own state, and an intended parent embarks on a legally precarious journey, and states can't necessarily be held accountable under international law for what may subsequently unfold. However, it is hard not to conclude from the existing case law of the court that the legal journey is particularly precarious for non-biological parents and particularly genetic but not gestational mothers in relation to whom the law has not kept pace with either social reality or science. One final point in relation to surrogacy speaks to how courts can successfully or unsuccessfully deal with parents deprived of their children. I have to use that word in inverted commas, but to these parents, these are their children in cases of this nature. In the Italian case, the minors' court spoke of the minor child being, and I quote, I use the words of the court because I think it's important, an instrument to fulfill a narcissistic desire of Mr. Campanelli and Mrs. Paradiso, or to exercise an individual or joint problem. All of this throws a consistent shadow over their possession of genuine affective and educational abilities and of the instinct of human solidarity which must be present in any person wishing to bring the children of others into their lives. I'm glad I wasn't subject to the same test when I became a mother of 2 children. Contrast the harshness of this statement with the approach of the Oslo City Court in the Norwegian case, which, although denying the applicant mother's suit, recognised and emphasised that she had everything necessary to offer X a good and safe relationship. In cases where the law imposes on litigants, for perhaps quite legitimate factual and legal reasons, a loss or suffering which will last a lifetime, I do think it is incumbent on judges and legal professionals to understand the additional damage which their words and their perhaps well-meaning sermons may wreak. The second category of cases I wish to touch on relates to the placement of children in long-term care and adoption. As the national authorities enjoy direct contact with the persons whose rights are affected by any decision alleged to violate the Convention, it's clearly not for the Strasbourg Court to don the mantle of a fourth instance tribunal and substitute its own assessment for that of the domestic authorities in this sensitive field. However, the margin of appreciation enjoyed by domestic authorities narrows when parental rights are restricted or removed, and the interests of children dictate that family ties may only be severed in very exceptional circumstances. Subsidiarity and the margin of appreciation dictate particular caution in cases of this nature. However, they don't absolve courts, either at national or particularly at Strasbourg level, from a forensic examination of the facts, of whether the reasons provided by the domestic authorities were both relevant and sufficient, and lastly, of whether the aforementioned exceptional circumstances standard is met. In recent years, some of you may be very familiar with this, the Strasbourg Court, in line with the principle of subsidiarity and the margin, has invested in what's called process-based review. This is a review which ensures that the Strasbourg Court is less intrusive of domestic court assessments and respectful of case and country particularities, which you can imagine in a convention legal space covering 46 states is quite important. But it places the onus on domestic authorities and courts to demonstrate that convention standards have been complied with. Some cases on childcare have illustrated how national procedural compliance with relevant references to convention standards can actually mask an emptying of the substantive rights of the parents and children involved. A good illustration of this is found in a series of Norwegian cases, of which the Grand Chamber judgment in Strand-Globen is the most well-known example. After the first applicant's child was born in September 2008, she and the newborn moved to a state-run family centre 4 days later. The mother had agreed, given her recognised need for guidance and support, to stay in the centre for 3 months. But when the child was 3 weeks old, the first applicant withdrew her consent to stay in the family centre. On the very same day, the child was placed in emergency care due to weight loss during the first weeks of life and what was reported as the mother's failure to understand and respond to his needs. The first applicant had sought assurances that after the 3-month stay, she would be allowed to return home with her child. When assurances in that regard weren't forthcoming, she had sought to leave. In her appeal to the Norwegian Social Welfare Board, the first applicant indicated that she and the child could live with her parents, that her mother was willing to provide support, and she was also willing to accept the help of the child welfare authorities. During the course of the lengthy proceedings, she gave birth to another child, which remained with her and her new partner. But both the Social Welfare Board and the City Court rejected the appeal, referring to the report of the Family Centre, which had considered that the mother was incapable of taking care of her child without support or follow-up. But again, let's look at the facts in a little more detail. From the moment of placement of the child, at week 3 of life, up until the proposed adoption, the child had had only 1.5-hour weekly sessions with his mother, which at the age of 5 months were reduced to 6 2-hour sessions per year, and then further reduced to 4 2-hour sessions per year. It has to be stressed that policy decisions relating to the choice of child protection scheme and the assessments which underpin them are legitimate and fall within the margin of appreciation of domestic authorities. Furthermore, this is a very difficult area for state authorities. A failure to act can lead to alternative violations of Articles 2, 3 and 8 of the Convention and devastating and in some cases fatal consequences. Assessments of safety and risk may be devilishly difficult. But the Court's case law sets out the procedural and substantive legal standards which need to be respected. Process-based review runs the risk of rendering the concrete application of those principles to the circumstances of an individual case excessively procedural. It can boil down to whether the national assessments were detailed, the process fair, the parents and child represented, and the final outcome underpinned by some reasoning. I won't go into all the detail of the Strand-Loban case. The Grand Chamber overruled the Chamber of 7 judges, which had found no violation of Article 8. It considered that the sparse contact which had been imposed on the mother and the child from 3 weeks after birth provided only limited evidence from which to draw clear conclusions regarding the mother's caring skills. The decision-making process leading to the placing of the child for adoption had been flawed, and Article 8 was therefore violated. As explained by several concurring members of the majority, the Norwegian authorities had failed from the outset to pursue the aim of reuniting the child with his mother. Process-based review, as we see from this case, cannot exclusively focus on the procedural steps taken. There needs to be substantial and procedural safeguards commensurate with the gravity of the interferences and the seriousnesses of the interests at stake. Of all the joyful things I have witnessed during my time in Strasbourg, and joy is not the emotion that you associate with the type of cases which Strasbourg judges deal, the response of the applicant and her family to the delivery of the judgment of the Grand Chamber in Strand-Loban was one of them. In the words of a Northern Irish judge to whom I'll soon turn, the applicant had, and I quote, lost that most precious of life's gifts, the chance to rear one's own child. The joy one witnesses in the court's recording, which you can see, it's accessible on the court's website, is a joy in being heard. I should add that the Strand-Loban case was not a Norwegian one-off. Prior to that Grand Chamber case, single judges, committees and chambers dealing with Norwegian cases had seen many cases of placement and adoption, and an overview of the caseload and its characteristics began to point to a systemic problem in that particular respondent state. Subsequent to the Grand Chamber decision, which addressed an individual case, but as I say, a systemic problem, the Norwegian Supreme Court adjusted its case law, providing guidance to national authorities and courts involved in similar child welfare cases. In a not dissimilar case, AR against Home First Trust, Lord Kerr had lamented in the Northern Ireland Court of Appeal in 2005 that the failure of the Trust's officers to be sufficiently alive to the requirements of the Convention had profound and unfortunate consequences in this case. It took the Court of Human Rights 15 more years than the Northern Ireland Court of Appeal to ensure that the Norwegian authorities would properly take cognizance of the same. The fact that the governments of Belgium, Bulgaria, the Czech Republic, Denmark, Italy and Slovakia all intervened before the Grand Chamber with diametrically different positions points to the social and political sensitivity of what the Strasbourg Court was dealing with in this case. But to return to the words of Lord Reid in unison, the name of Strand-Loban lives on as shorthand for a review of the legal rules and principles applicable in childcare and adoption cases. It is, on the one hand, a confirmation of the principles of subsidiarity and the margin of appreciation, but it's also a reminder that process cannot blind us to substance, particularly in cases involving children. As my time in Strasbourg progressed and when President, several extrajudicial speeches took as their central theme endemic and pervasive forms of violence, which are too often shielded from the glare of the law and from public exposure. This is because of where the violence occurs or the feelings of fear and shame which it seeks to instill. I am, of course, referring to domestic and gender-based violence. To my knowledge, there are few, if any, cases from the UK on the Strasbourg docket concerning this issue. However, regular headlines in this jurisdiction and in my own suggest that the investigation, prosecution, adjudication, and sentencing of offences in this field remain beset by problems. There were 1,625 prosecutions under the 2021 Northern Ireland Domestic Abuse and Civil Proceedings Act in 2022 to 2023, resulting in 840 convictions. This rose in 2023 to 2024 to over 2,700 prosecutions and over 1,500 convictions. The 2021 Act introduced a new standalone domestic abuse offence, as well as 2 child aggravators that can be attached to the offence. Over the last 2 decades, starting with a case called Opus against Turkey, the Strasbourg Court has developed a rich body of case law, pursuant mainly to Articles 2, 3, 8 and 14 of the Convention, which seeks to protect and compensate individual victims and contributes to greater awareness of the legal mechanisms and responses required at national level to prevent and, when necessary, combat this type of violence. Year on year, do we see in the cases pending in Strasbourg a positive shift in patterns of private behaviour and state action in their regard? Sadly not, or not enough. In 2023, in cases involving Bulgaria and Georgia, the court found violations of either Articles 2 and 3 of the Convention, combined with Article 14, against the backdrop of systemic failure by the relevant state authorities to address domestic and gender-based violence. These cases follow on from judgments against the same 2 states, as well as other judgments against Italy and Croatia in 2022. Bulgaria, the Czech Republic, Hungary, Lithuania, and Slovakia are amongst the 7 Council of Europe states which have refused to ratify the Istanbul Convention. Turkey withdrew from it, as you probably know, something which was also threatened by the previous Polish government. The court has recently handed down judgments highlighting the secondary victimization of a 12-year-old orphan in a case in which she had complained of sexual abuse, or the Moldovan authorities' failure to protect a victim of domestic violence and ensure continued contact between the victim of the violence and the children who remained with the father. The latter case is of particular interest because it highlights a recurring aspect of domestic violence cases, namely the blocking of contact or the injury of children to compound, supplement, or replace direct physical abuse. In the leading case, a case called Kurt against Austria, decided in 2021, the Grand Chamber adopted a judgment which marked a qualitative step forward in the perception of and response to domestic violence from the standpoint of the Convention. The facts of the case are as tragic as they are sadly recurrent in this field. A pattern of escalating violence directed first at the applicant mother and which escalated into murder-suicide, the applicant's 8-year-old child fatally injured at school by the father. The emphasis throughout the court's judgment is on the need for national authorities to take due account of the particular context and dynamics, as well as the known specific features of domestic violence. Where the threat to life arises in the context of domestic violence, then more specific obligations are triggered on the part of the authorities, starting with an immediate response to such an allegation or complaint. In a case called Vieru against Moldova, decided in 2024, by the time the case had reached Strasbourg, the principal victim of the domestic violence, which had been repeatedly reported to the authorities, was already dead. The severity of the violence, which her 2 children had witnessed for most of their lives, and the inactions of the authorities were such that the court refused to strike the case out, despite the fact that Moldova had presented a unilateral declaration recognising the violation of the Convention. Often in public discourse on domestic and gender-based violence, one finds references to vulnerability. Yet the victims of domestic and gender-based violence are not born vulnerable. They are rendered vulnerable on their journey from child to adulthood by the imbalanced social structures into which they're born, by the law and by lawmakers, and by attitudes and patterns of behaviour in their regard, which are ignored, permitted, or even endorsed by society, including the state. If we derive one positive thing from the 4 chilling hours viewers spend watching adolescence, it is surely a realisation of the brutal cost, not just to women and girls, but also, albeit differently, to boys and men of modern-day worship at the altar of certain types of masculinity. In the cases I've referenced, and the hundreds pronounced in previous years, the focus of the Strasbourg Court has been and must remain the actions and omissions of state authorities in relation to the direct victims of domestic and gender-based violence. But the silent and damaged children who have witnessed such violence should not be and cannot be forgotten when it comes to prevention, prosecution, convictions and sentencing. Even when a case like Vieru, the Moldovan case, is not directly about children, it's time for courts to pay greater respect to their story and account for what they have suffered when society and the state have failed to step in. In Northern Ireland, of the over 2,600 cases with offences with the statutory aggravator, over 1,400 resulted in a conviction in 2023 to 2024. There were convictions in 17 cases where there was a child-related aggravator in 2023-2024, but the aggravator proved in 8 of them. Time alone will allow us to develop a clearer picture of how this new model of legislation is working, but at least it provides for consideration of the too often unheard. Recent Strasbourg case law, for example, a French case called HW, finding incompatible with the Convention false-based divorce for breach of conjugal duties, demonstrates that outdated legal notions and outdated legal defences, if not resolved legislatively at national level, will inevitably be challenged before the courts. If the panorama I've presented to you thus far has been a little bit bleak, I apologise. So I suggest that we move on towards slightly sunnier uplands, if one is still allowed to use that expression without raising eyebrows. Although of all the guarantees set out in the Convention regarding the conduct of proceedings apply to children, over time the Court has insisted that they must be tailored to their maturity and evolving capacities, necessitating the development of particular rules and principles to ensure child-friendly justice. The Court takes into account the relevant international and European standards stipulated in the UN Convention, the Council of Europe Convention on the Protection of Children Against Sexual Exploitation and Sexual Abuse, otherwise known as the Lanzarote Convention, and the guidelines of the Committee of Ministers. Depending on the specific circumstances of the case, child-friendly judicial settings and proceedings may involve the rights enshrined in Articles 3, 4, 5, 6 and 8 of the Convention. The trial of the 11-year-old Venables and Thompson for the murder of 2-year-old James Bulger, a trial which I know you're all familiar with, is probably one of the first and best known juvenile trials in this jurisdiction and beyond. As regards their fair trial complaint in Strasbourg, the court held that a child charged with an offence should be dealt with in a manner which takes full account of their age, level of maturity and intellectual and emotional capacities, and that steps should be taken to promote their ability to understand and participate in proceedings. According to the court in that case, although special measures had been taken to promote the applicant's understanding of the proceedings, the formality and ritual of the court must at times have seemed incomprehensible and intimidating. There was considerable psychiatric evidence available, casting doubt on their ability to participate in the proceedings. In such circumstances, the fact that they had been represented by experienced lawyers was not sufficient for the purposes of Article 6, Paragraph 1. In 1999, when the Venables and Thompson cases were examined, the court held, after an examination of Council of Europe and relevant international standards, that there was no commonly accepted minimum age for the imposition of criminal responsibility. I know that this is an issue with which the Child Law Centre has engaged closely since then, and with subsequent Court of Human Rights cases on Article 3, such as Boyd, where vulnerability is really emphasised, it would be very interesting to reflect on what the court would find now, were that question before it. Sadly, since that 1999 case, the number of juveniles accused of murder or manslaughter has risen dramatically. With the nature of social media, certain actors on social media, access to and the content of pornography and online violence all cited as contributing factors. Whether at EU or UK level, it remains to be seen whether new legal instruments designed to tame the toxic effects of social media may find themselves to be the collateral damage of what I would refer to diplomatically as the new global reality unleashed since the beginning of the year. In addition, one notes the media furore which accompanies each of these cases, which renders quiet, considered policy reflection and brave decision-making much, much more difficult. However, I think we can say that some criminal justice lessons have been learned. If we return again, and I'm sorry for using it 3 times, but I think it speaks to what we're talking about. If we return to the themes in adolescence, I think for those not familiar with the field, the arrival of the SWAT team was quite simply stunningly upsetting. However, look at the depiction of the role of the appropriate adult, the sensitivity and immediacy of the legal assistance provided, and the psychological reporting, which featured so significantly in that particular series. But there are also real-life examples. They can be found, I would suggest, in the handling by the Irish authorities of the investigation and prosecution of the murder of Anna Kriegel in 2018, which are detailed in an Irish Times report following the conviction, and which are further illustrated by proceedings brought against those on social media who had breached publication restrictions during the trial. The Supreme Court just looked at this issue and gave a final ruling recently. Leaving criminal justice aside, which is too vast for me to address today, whilst Article 8 contains no procedural requirements, the court has held that a child must be sufficiently involved in the decision-making related to his or her family and private life, citing Article 12 of the UN Convention. The court has emphasised, however, that the right of a child to express his or her own views should not be interpreted as effectively giving an unconditional veto power to children without any other factors being considered and an examination being carried out to determine their best interests. As noted in the Moldovan domestic violence case that I've just mentioned, where there was blocked access to the children in the custody of the abusive parent, this is particularly important in such cases. This recognition of children as the subjects of rights is a long way from the dissent in Tyrer and the lack of autonomy recognised for children in the dissenting judgment in that case. As regards the court's own procedures, because people in glass houses shouldn't throw stones, questions arise regarding who can or should represent the rights of children brought before the Strasbourg court. In the Norwegian Strandloben case, for example, the Italian government had argued that the interests of the applicant birth mother and the adopted child did not necessarily align. It considered that if the court wanted to ensure that X's interests were looked after, it could indicate to the respondent government that counsel should be appointed for him. In a case called A and B against Croatia, this was done. The chamber case in that particular case concerned a complaint lodged by the mother and child that the domestic authorities had failed to provide a proper response to the allegations of sexual abuse of the child by the father. However, there were countervailing claims of physical abuse by the applicant mother. The chamber considered that the contentious nature of the parental relationship and a potential conflict of interest between the applicant mother and child meant that a lawyer should be appointed to submit observations on behalf of the second applicant child so that her rights and interests would be duly presented and taken into account. But the Croatian case is worth citing precisely because it is so unusual in Strasbourg terms. The rules of procedure don't provide for clear and accessible rules in this regard, such that I would suggest that the Strasbourg Court itself would seem to have some more homework to do. My fifth and last category of cases focuses on one aspect of a case decided just over a year ago and already alluded to by the Lady Chief Justice. As many of you will know, courts at national, European and international level have been seized in recent years by applicants concerned with the present and future consequences of what they claim is the failure of states to mitigate the effects of climate change. Whether one likes it or not, and as I'll explain, some convention critics are not well pleased, climate change litigation is now a disruptive reality as regards European law and established constitutional orders. However, it's important to remember that not all climate change cases are human rights cases, and, most importantly, from the perspective of a former Strasbourg judge, it was national judges in the Netherlands, Germany, Ireland, France and Belgium, to name but a few, and not the Strasbourg Court, which first debated the Convention as part of their national legal response in climate change cases. The early Dutch and German judgments, don't have time to go into the details, they were groundbreaking because legislative provisions presently in force were identified as the source of impermissible state interference with the enjoyment of fundamental rights in the future. In 2024, in 3 cases lodged against Switzerland, France and Portugal, plus 32 other states, the Court of Human Rights had to grapple with its first climate change cases. The essence of the complaints in all 3 cases, they weren't identical, but there was a common theme, was that state authorities had failed to respond adequately to combat the effects of climate change, and the applicants relied on Articles 2, the right to life, Article 8, the right to privacy and family life, and Article 6, on access to court. 2 of the 3 cases, including the Duarte case already mentioned, were deemed inadmissible for lack of exhaustion and lack of extraterritorial jurisdiction. The Portuguese miners had introduced their case against their state of origin and residence, but also against 32 other states. But in the Swiss case, the court found that the applicant Environmental Association's complaint was admissible, and it developed its case law on the standing of associations in the climate change context. It held that Switzerland had violated their right of access to court because they hadn't even examined if they could have standing to represent the interests of their members. The court also found a violation of Article 8, which encompasses a right to effective protection by the state's authorities from the serious adverse effects of climate change on lives, health, well-being and quality of life. The judgment was hailed by many and denounced by others. Lord Sumption regarded it as a good example of what he called Strasbourg mission creep, which he attributes to the living instrument document identified in the Tyrer case almost 50 years ago. He regarded the Swiss judgment as being fundamentally anti-democratic, and in response to those who support the Strasbourg Court's work, citing previous good decisions as evidence, he argued, and I quote, "This is actually a little like saying that Mussolini was fine because he made the trains run on time." Now, I received some extraordinary correspondence when a Strasbourg judge and president. One letter writer suggested that I would better spend my time and what he considered my limited skills waitressing in a cafe in the west of Ireland. I was the 17th president of the court and its first female, and I suspect I was the only one who got a letter like that. I wonder why. But I must admit that I never expected the oeuvre of the Strasbourg Court, in which I served, and of course I was sometimes a dissenter myself, I never expected the court's caseload to be compared to the work of Il Duce. Leaving extravagant comparisons aside, I refer to these climate change cases today for a reason, namely the identification by the Strasbourg Court for the first time of the relevance in some contexts of intergenerational burden sharing. This had formed the central plank of the reasoning of the German Federal Constitutional Court in its judgment of 2021, and also featured in the judgment of the Belgian Court of Appeal in a case which is still pending. In the Swiss case, Klima, the court emphasised that the intergenerational perspective underscores the risk inherent in the relevant political decision-making processes, namely that short-term interests and concerns may come to prevail over, and at the expense of, pressing needs for sustainable policy making, rendering that risk particularly serious and adding justification for the possibility of judicial review. It's important to stress that intergenerational burden sharing formed part of the court's reasoning in relation to its approach to standing and to the nature and scope of the positive obligations it identified under Article 8. Intergenerational burden sharing or equity didn't constitute a self-standing reason for the creation of new rights for persons not before the court or not even alive. This aspect of the judgment was certainly innovative, but it should be added that the climate change cases are a particularly good illustration when you read the three cases together, as one should, of strict subsidiarity and the flexible margin of appreciation in action. This short tour of distinct areas of Convention case law has sought to highlight the road travelled to ensure that the Convention, which was not framed with reference to children or, as we saw in the dissent in Tyrer, with them in mind, accommodates the power of children's rights alongside other interests in Europe's human rights machinery. Before concluding, however, given the turbulent times in which we're living, turbulent times which the Court of Human Rights was already witness to throughout the past decade, allow me to address a more general question of which one should not tire, namely the purpose and value of the Convention system, which is based on shared responsibilities and in which the national authorities here present play the fundamental role. As the Lady Chief Justice eloquently explained in her Thomas More lecture at Lincoln's Inn in November 2024, human rights have formed the foundation of Northern Ireland's legal system, playing a crucial role during the peace process and continuing to influence today as a key tool in advancing social justice across this jurisdiction. It's up to you where you prefer to locate their origin and effective core: the Magna Carta, the common law, the European Convention of Human Rights itself. From a convention perspective, what is relevant is not the legal basis, but that the rights and freedoms are effectively protected. In the United Kingdom, the value of the Convention has long been debated, often vociferously denied, and regularly chosen by politicians as a subject thought to attract critical voter support. My morning started early this morning as I listened to the Today programme on Radio 4 and heard of plans to amend the Human Rights Act in order to deal with asylum and immigration misuse, or indeed the still muted question of convention exit. So my morning today started as my morning as president started every morning. By referring to this latter point, I must stress that my intention is not to trespass into the political domain. However, I took presidential office in the heat of the debate on the Rwanda interim measure, and I left 2 days before the UK parliamentary election in July 2024. So I think I can speak on the record of the political heat directed at judges when there is opposition to what they do, how they do it, and the authority they exercise when they act. What independent judges do, as explained many years ago by Lord Bingham, is to interpret and apply the law, which, as he reminded us then, is universally recognised as a cardinal feature of the modern democratic state, a cornerstone of the rule of law itself. Of course, in Northern Ireland, as in the state from whence I come, the role which human rights have played in the shaping of the modern democratic state and the central role of the Convention in the Good Friday Agreement and constitutional settlements north and south, which resulted therefrom, sets both jurisdictions apart. As the Lady Chief Justice also emphasised in the speech, that agreement provided both human rights-related obligations and dedicated mechanisms to ensure compliance with human rights standards. When explaining the value of the Convention to UK audiences, I have in the past referenced the UK influence during its drafting, which sought both precision in how the rights were to be framed and symmetry between the Convention rights and those already reflected in the UK common law. I've also cited the closer alignment between Strasbourg and UK domestic courts in the application of the Convention brought about by the 1998 Act. This undoubtedly resulted in a reduction in the number of cases brought against the United Kingdom, but also in the number and nature of violations found. The UK is now the third lowest state, behind Germany and Ireland in terms of the number of applications pending per 10,000 inhabitants. Beyond the seminal cases in which the UK featured as a respondent state, its influence, whether in terms of domestic judgments cited and relied on, or interventions by the UK as a third-party intervener should also be mentioned. And in the written paper, I provide some examples. The brittleness at times of the domestic UK debate to which I've just referred thus seems, and I gave this evidence to the Gross Committee, at least from an Irish common law and continental perspective, to entirely overlook the effective influence and engagement of the UK with the Strasbourg Court over the years, and of the tremendous influence which UK judges have had through their judgments and their extrajudicial pronouncements. Lord Kerr's judgment in AR predated the Strasbourg Grand Chamber judgment by many years, and it is striking for its mastery of convention case law and principles, as well as for its downright humanity. But for anyone born on this island, not least someone like myself, whose maternal roots lie in Ballycastle, the Glens and Glenchesque, the value of the convention is also easily explained in terms of its fundamental contribution to peace, prosperity, and at least degrees of historical recognition across the convention legal space. To the convention critics, I always say, I agree. The Strasbourg Court should persevere and try to be rigorously better in its reasoning and ever more balanced in its approach. But I would also ask them to look within and beyond Europe's frontiers and shores and reflect on a world where the checks and balances of even venerable democracies can be easily and rapidly dismantled, where violence begets violence, and where women and children are primarily the victims, and where we see how that violence can be met when international law is set to naught with impunity. Ladies and gentlemen, I thank you very much for your attention.
Do you want me to take it? Yeah. Okay. Can you hear me all right at the back? Yeah, I think this is on. Well, that was a tour de force, which is resonating with me on very many levels, given the scope of the lecture, Síofra. We are very grateful to you. I'm sure some of you have questions or comments which our speaker is willing to address. Can I ask, does anyone have a question or a comment? No?
I made them work too hard.
Silence. You did cover a lot of ground, so anything? Paddy, maybe? Do you have anything? No? Yeah, I think I see someone at the back.
Policy Campaigns Comms Manager at the Rainbow Project. Just to say thank you so much. That was an absolutely fascinating lecture. It was really, really interesting. I'm keen, I suppose, to hear your perspective, and you did touch on it within the lecture, but on the kind of the convention as a living document, and your assessment in particular of how UN conventions broadly, but specifically the kind of European Convention has adapted and shifted and changed to recognise and uphold the rights of LGBTQI plus people. I think particularly in the context of, recent kind of national court judgments in Britain, but also in the kind of changing nature of debate around the world. I'm particularly interested in your view on how the court has upheld the rights of trans people and how that might be challenged in the coming years. But once again, thank you so much. It's so much food for thought there. Thank you.
Okay, yeah, you go.
Thank you very much. Can you hear me at the back?
Yeah.
I did expect that I would get a question along these lines. And I think I'll preface my answer by saying something which is important. I am now a former judge and former president, and I've been using my sabbatical to provide, I think, a public service defending a system which needs defending. But I'm careful not to trespass into what are pending legal cases or delicate ongoing issues at national or European level. I know well the UK Supreme Court judgment that you're referring to. I'm sure we've all read either the summary or the whole judgment, and most of Europe, most of legal Europe has done the same. I won't trespass into that area, particularly because it's still being digested within the 3 jurisdictions of the United Kingdom, never mind beyond, and I think it would be misplaced for me to take a position on it. What I can speak to more generally is your question of, for example, the living instrument generally, and you reference LGBTQI rights in particular. It's a fascinating tale, and I think it's a tale which the critics of the convention should pay close attention to. Those who criticise the convention for exceeding its mandate don't like the living instrument document and generally adhere to an approach to parliamentary sovereignty which excludes human rights as a check and balance within our democratic systems. But the living instrument document has been with us for a very, very long time. There have been numerous intergovernmental conferences. There have been additional protocols. Subsidiarity in the margin were introduced into the preamble. The living instrument doctrine has never been called into question by the states parties. So it's with us, and it's what the court deals with. As regards, I will talk to LGBT in particular, because the Q and the I are the novel issues, which are really, some have been before the court, very few. There's an intersex case which was deemed inadmissible by the court in relation to France. If you look at the cases, you see what the court was doing was looking closely at the level of evolution across the convention states and the development of international and European standards. And you saw in Goodwin it taking a very, very important decision. As regards, however, LGBTQ rights, what I've seen, and I've worked in cases relating to Georgia, Bulgaria, the Russian Federation, these are all no longer the Russian Federation contracting states. So what the Convention Court has to do is deal with a legal space in which there is variable geometry across the states. It can either force or it can, what I call, nudge and pull. In relation to my state, Ireland, it nudged and pulled on several extremely sensitive and divisive issues, reproductive rights being one of them. And it effectively had a very significant but quiet voice in the background as legislation changed, judgments were adopted, and finally a referendum took place on two particular issues. In one case, a globally groundbreaking referendum. Was it better to nudge and pull, or should it have gone full steam ahead and impose a harmonised standard? The convention is not a harmonising text, it's a minimum standards text. So that's why, for example, I use the issue of gay marriage, something which has not been recognised as a convention right. Instead, the court has much more carefully recognised a right as a minimum standard to have your same-sex relationship recognised in some legal form or another, with the recent judgment of the Grand Chamber in Fedotova, a very good example. You see in that judgment judges who wanted to go further. They didn't want to just look at the question from the perspective of Article 8 and the right to privacy. They wanted to look at it under 8 and 14, the right not to be discriminated against. I'm perfectly aware of the criticisms that people can have of the court when they would regard the court as being excessively timid. I think you have to look at the 50 years of jurisprudence on the living instrument. More good has been done than harm, much, much more good. Our societies are much more tolerant, inclusive, pluralistic, and those are convention values, and I would imagine they will continue to be. But if the court has gone in there with a hammer on any sensitive issue, or ones in which states are moving at different rates, then it actually causes, in my view, more harm than good. So I am very much in favour of the margin, the living instrument, and careful calibration of the case law, ensuring that, however, human dignity is protected. I hope that provides a reasonable response while also avoiding entering into the domestic debate.
Thank you. Thank you for the question and the very comprehensive response. Anyone else? Any thoughts or questions? Yes.
Thank you so much for the masterful. Thank you very much. Thank you for the microphone. Thank you very much for the masterful overview of those issues. I was wondering, you spoke a little bit about the kind of perceptions of the court in the UK context, perhaps, but of course the ECHR, you're looking at a kind of continental perspective as well, and I wondered if you would like to comment or could comment on some of the pressures, maybe, or criticisms as they seem to you from Strasbourg and more widely than the UK context. Do you see different pressures or dynamics at work of relevance for the court and its work?
Thank you very much. And in fact, thank you for the question, because it allows me to emphasise that I spoke of and to the UK because I'm speaking within the UK. I think it's important to make that point. It's not only the UK that has been critical of the convention system, far from it. In the time in which I was in Strasbourg, I often, because we talk about the turbulent times that the world is living now, and I mentioned the fact that, in fact, for Strasbourg judges, it's been turbulent for a decade. I arrived in 2015. It was the year of mass migration, followed by, there was Brexit, of course, a not convention issue, but it has convention implications within this jurisdiction and other areas. The attempted coup d'etat in Turkey in 2016, the invasion of Ukraine, which dates back to 2014, but of course then there's the military invasion in 2022. A pandemic, why not? Raising totally new issues of human rights which touch on every aspect of the convention and its principal articles, and the court was having to respond to them. I mean, the crisis was just one after another. Throughout this time, you've seen it yourself, you see it in the newspapers, asylum and immigration has become an extremely hot topic, either because the reality of it is in the state in question there is a real problem with asylum and immigration, or because there has been a decision to render asylum and immigration a topic around which discussions can become rather heated, I'll put it in those terms. So in France, there was the beheading of Samuel Paty, the school teacher, by Chechens, who were children, I think, of Chechen refugees in France. This led to the French authorities really going through the whole Chechen community and seeing who they would like to expel, who had become radicalized. So cases relating to the expulsion of Chechens from France was an extremely hot topic. An Uzbek national was expelled from France despite a Rule 39 interim measure prohibiting this. The Conseil d'Etat came out indicating to the French government that they must respect the Rule 39 interim measure, and the Interior Minister at the time quite clearly said, okay, good luck Strasbourg, but I'll do my job and they'll do theirs. Now, all of this is happening, remember, against the background of states criticising Turkey for failing to respect court judgments and release opposition figures who had been detained and who were the subject of Strasbourg court judgments. States vociferously criticising the Russian Federation not only for its actions in Ukraine, but also for its treatment of opposition figures like Navalny. States criticising countries like Poland and Hungary for the rule of law backsliding that one was witnessing, and which is the subject of numerous judgments of both the Strasbourg Court and the Court of Justice of the European Union. So it was quite clear that the Convention is very important and useful for certain issues, but the Convention is regarded as a hindrance for others. But if you look, and I do use the UK as an example because I think it's a very impressive one, is that until recently the UK was the country with the lowest number of applications per 10,000 inhabitants of all the 46. The UK docket has very few asylum and immigration cases. Of course, there are some. If you look at the Article 8 case law of the court, it very clearly starts in all cases by saying states have the right to regulate the entry and residence of non-nationals on their territory. And in Article 8 cases, a case called Ndidi, if you want to look at it, the court had made very, very clear that subsidiarity in the margin of appreciation means that where an independent and impartial court has examined correctly and in detail a particular complaint, applied the relevant convention standards and come to its own assessment of proportionality, the Strasbourg Court will not step in, even perhaps if its assessment of the merits might be somewhat different. That's subsidiarity in the margin of appreciation. Now, those who criticise the Convention as being the legal instrument which binds the hands of all national decision makers never cite the Ndidi judgment. nor do they cite the UK Supreme Court decision, unanimous, which found the Rwanda policy unlawful and made very, very clear in a paragraph which wasn't there, I imagine, by accident, that the unlawfulness stemmed not only from the European Convention on Human Rights, but also from national law, from the common law, and from other international legal instruments. So it's been a difficult time, but I think we are perhaps witnessing examples around the globe of what happens when you don't really respect the rule of law. And the rule of law is not about protecting elite independent judges. It is about protecting the rights and freedoms of people in truly democratic societies, in which we have all had the benefit of growing and living in. And I have always made very clear that I think one of the fundamental responsibilities on our generation is to ensure that the next generation benefits from the same environment in which to prosper. And I don't mean economically, but of course that generally comes with truly democratic societies.
Okay, I think we may have time for one more question or comment if anyone has it. Can I ask you something, Síofra, just about, I was struck, as I think I said in my opening, that the Portuguese children came to the plate in a climate change case. I always thought it was ironic that it was the Portuguese children and the Swiss pensioners who came forward. I know there's the French mayor in between. But if you can, I mean, the shape of these cases, it seems to me, is really based upon the positive obligations within the Convention, utilising Article 8 and then Article 2, obviously. Where do you see this going in terms of development? I mean, is it really an emphasis upon those positive obligations? And also the issue of children as litigants generally, is there any other relevant Strasbourg jurisprudence on that?
Thanks to the Lady Chief Justice for passing me that hot potato. It's a very good question, and I do always emphasise, I think it's important to read the three judgments together. So perhaps the minor applicants, they failed in their case because, as I explained, there was non-exhaustion, which is excruciatingly important in Article 8 cases, particularly in Article 8 cases. How could the Strasbourg court launch into an examination of complex scientific evidence when the evidence was never before a national court, and then find that state in violation of the Convention? That's contrary to the whole logic of the Convention system. Secondly, extraterritorial jurisdiction. It's an important limitation on the Convention and how it functions. So yes, it is ironic that the Swiss senior citizens won in their case, but they won a certain type of victory, an access to court complaint, which succeeded in relation to the standing of the association. And I very clearly stated that was a definite innovation under the Living Instrument document. The court had signalled in environmental cases that standing might have to be adapted given the fact the complexity of this type of litigation and the realities of modern society meant that associations are often the only ones who can represent a certain interest. And if one of the underlying principles in the Convention is effective judicial protection of your rights, can you simply set at naught any judicial protection simply because we're all affected by climate change, so nobody can be individually or sufficiently concerned? The positive obligations line. If you look at the Article 8, part of the court's reasoning, positive obligations is the absolute key. But pare down all the paragraphs, and remember, a judgment like that has to be deliberated and signed off by 17 judges. It was a 16-1 judgment. Judge Eike, the judge elected in respect of the United Kingdom, was the sole dissenting judge. If you write a judgment on your own, you might omit some paragraphs, but you don't have that. You don't have that luxury in a collegiate deliberation process, and you have to proceed as carefully as you can. It boils down to a due diligence obligation on states to adopt mitigation measures. It is nothing more nor less. And to those who throw their hands in the air and go, what? I turn to them and I say, have you heard of a case called Airy against Ireland? Now, it's an Article 6 case, it's not an Article 8 case. But what did the court find under the living instrument document in ERI? A, positive obligations. Secondly, it recognised the fact that sometimes the protection of human rights and freedoms can have a certain cost. And running through the Convention case law is a requirement on states to effectively protect human rights and freedoms. So people in academic articles and blogs shout out the word landmark judgment. I always say, steady on. We'll see if it's a landmark judgment or not. That will take many cases to determine if it's a landmark judgment. So in a sense, I'm answering your question by saying, we'll see.
Yeah.
But of the 3 cases, if you look at them all together, it's a much more balanced output than some of the critics would have you believe. Look at the detail, don't just look at the blogs and the headlines. And I think the court decided to look at Article 8, but look at the Belgian Court of Appeal decision, and I would stress that's still pending, so we'll see what the highest Belgian court decides. They looked at Article 2. And recently the Court of Human Rights, in an Italian case under Article 2, I can't pronounce the Italian applicants, it was something like Canivucucolo, against Italy, developed significantly the Article 2 obligations on states in relation to environmental cases. They did hold that the standing innovation and climate change case is limited to climate change cases, not environmental cases. Judge Eiche was in the majority. In fact, I think it was a unanimous judgment in that particular case. So there are other climate change cases pending. I think there are about 8 to 11 cases. Many of them are brought by associations. It's not a surprise. And all of them are brought against what I could, I think, refer to as prosperous Western European contracting parties. So we're talking Austria, Germany, Norway, Italy, the United Kingdom. The Court of Appeal and the UK courts generally have been dealing with climate change cases. No court is going to be spared from these cases.
Yeah.
Litigants go where they feel the state has acted inappropriately or failed to act. They go to courts. And we're lucky to have those courts. Those courts must remain within their judicial lane, I entirely agree. The Scottish courts recently had a case in which I was happily surprised to see them cite the Klima judgment. And prior to the Klima, the Swiss case, the Court of Appeal had looked at an appeal in a case pending before it, and the reasoning of the judge who threw out the case said, you're relying on the convention, but the Strasbourg court has never said anything about Article 8 and climate change. Well, it has now. And it said something after, particularly the Dutch, French and Belgian courts had acted. The German court also had handed down an extremely important judgment, but based themselves on German constitutional law. The Irish Supreme Court had also handed down a judgment during COVID, basing itself on Irish statutory obligations and avoiding the convention and constitutional legal complaints, but they could do that. The Strasbourg court couldn't avoid the convention complaints. Yeah. So time will tell. There are cases pending, and no doubt there will be more children.
Thank you very much. Sorry if I put you on the spot there, but Eri is in a case against Ireland from memory of quite a vintage, and was an access to justice, Article 6 point about a woman wanting to vindicate her rights and access to court in the context of domestic violence. I think, I could be, it's a while since I've read it, but nobody would actually blink an eye in relation to that, which is your point about access to make your case and your claim.
Yes. In the context of domestic violence and the absence of the possibility of divorce in Ireland at the time, you had to apply for judicial separation. You could only do that before the Irish High Court. To appear before the High Court, you needed legal representation, but this was beyond the means of certainly this applicant and many, many other applicants, and hence the court found by a majority, with criticism from the minority, but in a chamber, they found a right of access should involve some form of assistance, whether the reform of procedural rules to allow it to become easier or reform of legal aid provisions, a subject which I don't know about this jurisdiction, but in the South this is still the subject of ongoing policy reform groups and proposed legislation.
Yeah. All right. Well, I don't know about you, but I could go on for quite a while. And Judge O'Leary has been very, very generous with her time in answer to questions and also in providing this tour de force in relation to current issues, children's issues, and the purpose and importance of the convention. So can I ask you to show your appreciation for her as I close the questions? All right, so just to finish off, before the drinks reception, we have one last address from Alicia Toll, who's chairperson of the Children's Law Centre. Alicia.
Good afternoon, everyone. I have the pleasure of closing this afternoon's event. But before I do, I want to thank you, Lady Chief Justice Keegan, for your earlier acknowledgement of Paddy and her contribution to children's rights. As you've already heard today, this is the final Children's Law Centre lecture under Paddy's tenure as the Centre's director. And for my part, as Chair of the Board of Trustees of the Centre, I'd also like to record our thanks to Paddy for her dedication, her service and her leadership. Having worked closely with her over the last number of years, I have nothing but admiration for her tenacity, her bravery and her unwavering commitment to children's rights. Thanks, Paddy. We are deeply grateful to Judge O'Leary for being with us today and for delivering such an insightful and thought-provoking lecture on the role and the contribution of the European Convention on Human Rights in the context of children's lives. Your reflections have provided an invaluable perspective for all of us here, both in person and online, to consider in our own spheres of work. Thank you sincerely for sharing your time and your wisdom with us. Very shortly, I would like to invite those that are here in person to a short drinks reception where hopefully we can continue that conversation. The drinks reception is hosted by the Bar Council, and I want to thank in particular the Chair, Mr Donal Lunny, KC, for their support once again this year. I'd also like to thank the Bar of Northern Ireland for allowing us to hold the lecture in the Old Bar Library. And I would particularly like to thank Lisa Mays and Donal Hanaway for all their support in the run-up to the event. I want to thank Judge O'Leary for agreeing to deliver our 2025 lecture and also for participating in a number of meetings and engagements today and tomorrow while she's in Belfast. I'd also like to thank the Lady Chief Justice for chairing today's lecture. And as a token of our appreciation, we have a small gift for you both.
Thank you very much.
Thank you very much.
Thanks very much.
appreciated.
Thank you. Thank you.
Thank you very much. I also would like to take the opportunity to thank the fantastic team at the Children's Law Centre for their work in bringing today's lecture together. They have made it look so very easy. In particular, I would like to thank Fergal McFerrin for leading in the organisation of today's event, and also Sarah McCauley, Sam Nelson and Paul Hamilton for their support in the administration and the communications, and also for the live streaming of the lecture. Finally, I just want to thank all of you who have attended here in person today and online. I'll have no doubt that you'll have found Judge O'Leary's lecture of great interest and hopefully leaves you with plenty to consider. All attendees, whether in person or online, will receive a copy of the lecture by email today, or following today's event, maybe not quite today. For those attending in person, you'll also find the details of other upcoming training and events from the Children's Law Centre and how you can support the work of the Centre that's in the packs that you've been provided with. If you have any questions about the work of the Centre, The staff will be here circulating after the lecture, and they're all wearing name badges, so you'll be able to spot them easily. But for now, I'd like to draw the proceedings to a close and invite you to join us next door for a drink. Thank you.
Thank you. That was great. Well done.